Such a sad, sad song that I thought you had to hear it in honor of the fact that torts come and torts go. Hence, I'm wearing my heart really not on my sleeve but on my chest. I'm so sad, I'm forlorn, as she cries out, "Oh, damn-ages," and she thinks maybe she can sue somebody, but she determines, as she's singing plaintively there in the song, that the penal code is silent on the issue, that there doesn't seem to be any sort of recourse for her broken heart, that a guy don't have to mean it when he kiss you. And she's right. Torts come and torts go. And sometimes wrongs which we used to right are no longer even necessarily viewed as wrongs. If they're wrongs, they're just social wrongs, faux pas, problems with etiquette, rather than things for which we will allow legal recourse. And one example of that, obviously, is, if you've been following the news in the last few years, is alienation of affections, or seducing someone away from someone else. In honor of that, I'll just show you very briefly, proudly, my shirt of George. You may remember George from Seinfeld. He posed for a portrait, and you've got George there just in his boxers, sans anything else, and it's entitled "The Timeless Art of Seduction." Yes, George is obviously seducing someone, seducing the camera, seducing the painter. And the idea at law is, not too long ago, was people could be sued for seducing someone. Let's say you were engaged to be married, and someone comes along and seduces you, takes you away from your betrothed. Let's say you are married, and someone comes along and takes you away from the person to whom you are married. That could be alienation of affections. Now, very recently, in North Carolina, a case was brought by an aggrieved ex-wife against the other woman, the woman that stole away her husband. And she did win a judgment. But this is very, very rare. It made the news because, in fact, it is counter to the trend of the last 50 or 60 years, which has been to move away from alienation of affections and recognize that as tort law grows and changes, some torts arrive on the scene and some old torts disappear. And most states have pretty much moved away from alienation of affections and recognize that if a relationship could be terminated via a third party's seducing ways, via the ways of a Lothario, that is perhaps poor behavior, but it is not the type of thing which we're going to allow lawsuits about. The only real major exception to this that I can think of is not the North Carolina case, but imagine you go to see someone in a professional context. Let's say you and your spouse are having marital difficulties, so you go to a marriage counselor, and then the marriage counselor sleeps with your spouse. Well, that's not really alienation of affections that you would be suing him or her over. You would be suing him or her over what? Breach of fiduciary responsibility, malpractice, other claims based on the professional relationship that that person should have had with you and your spouse, rather than sleeping with him or her. There are some other torts which have arrived on the scene. I don't want you to think that it's simply there are these areas where we can't sue. You know, a guy kiss you and there's no issue. There are cases where you can bring an action where 100 years ago there would have been no tort at all. They wouldn't have even had a name for this problem. One example of that would be the intentional infliction of mental or emotional distress. I saw a cartoon one time of a pilot and a co-pilot in the front of the plane, obviously, and the pilot says to the co-pilot, "The fuel light's on, Frank. We're all going to die." Wait. Oh, my mistake. That's the intercom light. Well, you can imagine all the people on the plane. In fact, the cartoon has all these petrified people. You can see all the windows, and they're all petrified because they've heard this horrible thing on the intercom that they're all out of fuel. Would that be intentional infliction of mental or emotional distress? No, because it was not intentional. I do think if somebody keeled over from a heart attack, say, it could be negligence. There might be a claim for damages caused by the sheer stupidity of a pilot or co-pilot who doesn't know the difference between an intercom light and a fuel light, but it's not intentional wrongdoing. Intentional infliction of mental or emotional distress is a newfound tort of the 20th century into the 21st century. It involves wrongful, intentional misconduct. And so an example of that, real case, involved a man who was depressed, taken into the home of his friends, a married couple. The couple went off to work. They came back at the end of the day and discovered that their friend had killed himself. He'd killed himself in a grisly fashion. He'd slit his wrist there in the kitchen. And the couple, of course, was traumatized by what their friend had done. They ended up suing the estate of their late friend and getting a judgment against him for intentional infliction of mental or emotional distress. Now, you may be thinking, well, wait a second, he didn't intend to cause harm to them. Well, you don't have to intend the harm, remember. You just have to intend the wrongful conduct. And a court held that it was wrongful of this man to, one, to kill himself, but two, to do it in this way, in his friend's kitchen, in such a way that it was bound to horribly upset them. We may sympathize with this poor man who committed suicide, but a court found that you could still have a judgment against them. The key thing in this area is it's got to be intentional, and it's got to be pretty darn bad. We're not talking about just kind of crude, rude behavior. I mean, we're here in a society in which people behave crudely and rudely all the time. And lawyers would have a field day if you could simply sue over any old insult that occurs. What you need to show is something outrageous. You need to show a pattern of behavior that is ongoing, or such an outrageous deed that it sort of shocks the average person. The average person says, that's beyond the pale. Let me give you a couple of examples to illustrate this. Let's say I am addressed as Baldy. Well, I'm bald, and somebody calls me Baldy. Can I sue him over it? Well, this is America. You can always sue. Will I win? Probably not. It's not really grossly beyond the pale, is it, to call somebody Baldy or fatty or loser or jerk or whatever. But if you had an ongoing pattern, let's say in my classes here at University of Florida, let's say the students orchestrated a campaign where on a daily basis people would come in and they'd crack eggs on my head or near my head, and they'd call me Baldy, they'd say, hey, billiard ball man, and it went on and on and on and on. At some point, that pattern of behavior, even if it was done just once, would not be enough, but as a pattern might be sufficient for me to sue for intentional infliction of mental or emotional distress. What the courts usually ask for in this situation is they ask not only for gross behavior beyond the pale, but they're looking for physical manifestations of harm. They don't want someone to simply say, I was upset. They want someone to say, hey, I got an ulcer. Hey, I had to be hospitalized for depression. Hey, I was so upset I couldn't go to work anymore. I needed psychiatric treatment. That's the type of thing they are looking for. I had a friend in college, and his name was Bill Dean. I don't know what it was about Bill Dean, but he really, really apparently irritated some people at a particular fraternity where I went to school. It was a small enough college that everyone pretty much knew everyone else, except at the very beginning of the year. Bill Dean, people didn't like him for whatever reason, and people at this fraternity, we weren't sure which people, but we were pretty sure it was a particular fraternity, would go to the bathrooms there at this small college I went to, and they would write F, and then you can add 3 more letters to it, F Bill Dean there in the bathroom. And they would write it over the light switch, and they would write it in the cafeteria, and they would write it in the academic buildings, and they'd write it everywhere. And finally, I'm convinced people were writing F Bill Dean who didn't even know Bill Dean. They just thought it was a neat thing to write there. And eventually, people didn't even write F and then fill out the rest of the word, Bill Dean. They just wrote the letters FBD. And everybody knew what it meant. It meant F Bill Dean. Well, if I had been Bill Dean, I would have been grievously upset. I think I would have had ulcers. I think I would have sought a therapist. I think I might have had a case. But for whatever reason, Bill Dean just didn't seem to be that upset by this. I don't think he had sufficient harm for a court to recognize the tort. The tort is too easily asserted, and so courts look for something pretty darn tangible as proof that you've actually been harmed in order for you to succeed in such a suit. So, there are torts which come on the scene, new torts. There are torts that disappear from the scene, at least in some instances, like alienation of affections. There are newfound torts which are sometimes created through law review articles. The classic example of that, the reasoning behind it, was invasion of privacy, first argued in a Harvard Law Review article in the 1890s. And there are some torts which are theories which have never yet been accepted. They've never really been found in the cases. People have advocated them, but they haven't come, they haven't gone, they've just never been. And one example of that might be what the song was all about, that in love and war, almost everything's fair. And ordinarily in love and war, you really can't bring a lawsuit and expect to win. And I'll give you one last example. Malparenting. Those of you that are parents or will be parents, listen up. There was a lawsuit brought by a young man a few years back. He sued his parents. And basically what his contention was, I'm an ass. And of course we know who to blame for being an ass. It's always your mom and dad's fault, right? She or he blamed his parents. He said, I'm an ass, and my parents are to blame, and they ought to pay me. They ought to pay me damages. Well, you know what the court said? The court threw it out. And the irony, as one wag pointed out, is by bringing the lawsuit, the young man actually proved his case. He actually proved he was an ass by suing his parents based on these circumstances. But what a court said, in effect, was we just won't recognize a case for malparenting. Malparenting as in the malpractice in the profession of parenting. Negligence in parenting was not accepted by this court as grounds for a lawsuit. I suspect judges, just like everybody else who's been a parent, looked at the situation and said, there are just so many things people could be sued on in terms of wrong choices, wrong decisions, things that even the parent regrets later in terms of how they raised little Billy or Betty. And so the court just didn't want to open up the floodgates in that area. Now again, just like torts generally, if you shift the pattern a little bit, you can always come up with a different example where maybe a lawsuit would be acceptable. Maybe not alienation of affections, but certainly a suit for malpractice or breach of fiduciary duty if you're talking about a professional who sleeps with your spouse. Maybe not malparenting, as in negligence in parenting, but what if it's intentional wrongdoing? What if your parent actually physically, sexually, mentally abuses you in a grotesque manner? What do you have there? You have a lawsuit that certainly can be brought, can be successful on, but it's not based on negligence. It's not based on malparenting, making poor decisions, making mistakes. It's based on intentional, wrongful, abusive behavior. So there are all these distinctions that have to be recognized in law, and the grand theme, of course, is the courts are always available for claims to be made, always available under our great common law for niches to be filled and for basically envelopes to be pushed and for other pockets to be what? Pressed back in and restrained. And so you see it from all directions. Torts come, torts go, torts never were, torts always have been.